Mr. Rodrigo Lobato. He's a noted legal consultant and author from Brazil. An expert in public law and constitutional law, Mr. Lobato is also a prodigious writer. Some of his works include Constitutional Appeal in the Realm of German, Spanish, and Portuguese Constitutional Law, and Religious Freedom, Fundamental Right in a Democratic and Touristic Society. We are honored to have you here, sir, today joining us from Brazil. Thank you so much for accepting our invitation, and I yield the floor to you, sir.
Thank you, thank you, thank you. Am I audible?
Yes, sir. Okay,
thank you. Thank you again. This is a great incommensurable honor to be here today. I'm practically from the other side of the planet here now, and it's almost 5 a.m. here in Brazil, but I couldn't miss this opportunity, and I want to thank Delhi University, I want to thank Ethiccraft Club, I want to thank Professor Dr. Seema Singh and Professor Raman Mittal for this great opportunity to be here, and I want to also congratulate the previous speakers for their insightful ideas, and it also has been today a great opportunity and honor to learn from you and hear these powerful ideas. So thank you again. I would like to start saying that spirituality and law actually has been for some long years a thing that is very close to my heart, and this is a great honor again to be here talking with you about these ideas. But actually today I would like to talk about my specific theme is about spirituality and its possible relationships with constitutional law, and not only constitutional law but science also, and from the perspective of quantum physics that I also have been studying in its interconnection with constitutional law. And to start with, I'd like to remember here and quote actually a well-known here constitutional scholar called Francisco Pontes de Miranda, where he wrote in his a book in the end of the 60s, called Commentaries on the Brazilian Constitution of 1967, and he wrote a sentence. He said one thing that is very important in the realm of constitutional law. He said, and I quote, that against the Constitution, nothing goes forward. Rather, it only perish. And here today, and with this idea in mind of constitutional law and spirituality, I would go further and to say, actually, against the Akash, nothing goes forward, even the Constitution. What remembers me also the lecture of Otto Bachhoff, a German constitutional scholar and former judge of the Federal Arbeit Court in Germany. And he wrote a masterpiece called Verfassungswidrige Verfassungsnormen, translated, this is entitled Unconstitutional Norms, Constitutional Norms. So how the Constitution could be unconstitutional. And this is actually a little bit curious because we had to also go back to Kelsen's spirit theory of law, where he said that in the chain of the formal validity of law, in the chain of the formal validity, at the top of the constitutional order and above the Constitution is the Grundnorm, the fundamental norm. What I have been trying to understand for quite a long time is what is this Grundnorm? And when I catch this idea of spirituality, I try to bring this idea of spirituality to the realm of constitutional law. I think that above the Constitution, above the constitutional law, and the proper idea of constitutionalism is spirituality. And talking about the concept, if possible, a real concept, because it is a multifaceted expression or a semiotic element, spirituality, I would say that spirituality, first of all, is not religion. Spirituality is beyond religion. Spirituality is a realm of possibilities that all we as human beings, and not only human beings, but all that exists in this universe, can connect with the oneness, with the cosmos, with the akasha, with the A field, that quantum Veinkel field that is called akasha. And here today, the idea that I would like to bring to you and expose here is how can and must actually constitutional law be pounded to the idea of akashic values. And actually, I wrote for this conference with Mr. Abhinav Kumar a full paper on that entitled Beyond Pure Constitutionalism, From Structure to Akashic Values. And what is pure constitutionalism? What I call pure constitutionalism? First, what is constitutionalism and constitutional law? On a general basis, constitutional law is the general law, the general set of rules and principles and norms that regulate the structure of the state, that found the state, its branches, the government, and its composition, and set a declaration of rights, and etc. And also obviously the relation between citizens and the state, the political community. But what I call here pure constitutionalism is like the sum of three basic trends that constitutional law passed in its evolution, in its development through space-time. And first of all, I would like to talk about the first trend, that is contractualism. And we all know about it, contractualism. The idea of a contractualism is the contractual approach of constitutional law is where, like in the 12th century and further, and based also alongside the idea that was further advanced only in the 16th century with Hobbes, Locke, Rousseau, and other great thinkers and philosophers. The idea of contractualism was to establish, by the idea also of constitutionalism, that a formal document, a formal covenant, would establish and found the society, the political community. In this political community and through the social covenant, man would see their powers, his powers, and his liberty to a sovereign authority founded upon, under these social covenants in order to protect his most core values or goods, as would say Locke, his liberty, his property, and also liberty, property, and also his own rights, obviously. But the problem with contractualism as a trend of constitutionalism and constitutional law is that, and as an example, a great example of that was the Magna Carta of King John from 1215. The Magna Carta wasn't actually a constitution in the proper sense of the term, and the modern sense of the term, but was a declaration of rights, and not also a declaration of rights, but actually a declaration of privileges. And the idea underpinning this declaration of rights was not to concede rights as a formal guarantee and substantial guarantee of rights against the state, but actually to formalize the social covenant between King John and his subjects. And what is actually the problem with contractualism or contractualist approach? As a matter of fact, we still have it under the idea of constitutionalism, constitutional law, but it has been developed since that time. But at that time, pure constitutionalism with the idea of contractualism or the contractualist approach was that the formal covenant, the social covenant, or these virtual elements that bounded the uh, citizens and the state under the idea of political communities do not have any concern with the substantial problem of society. Uh, and I say that as a form to comprehend that contractualism was just a formal aspect of constitutionalism, not having at that time any further and deeper concern on the aspect of liberty and the evolution and the moral evolution and the spiritual evolution of man. And although we still have it in all aspects of our modern constitutionalism, the second trend after contractualism was that idea of structure. Some constitutions, and especially the first constitution of the world, the United States America Constitution from 1787, brought deeply this idea of structure. The original text, and I say original, excepting the amendments from 1791, and after that year, I say that that constitution was a great example of structure because the original text of the constitution with 7 articles, if I remember, just established the foundation, the structural foundation of government. So what is the government? What is the regime? What is the form of the state? What is the type of election, the procedures of election, composition, and the term of exercising power. But the constitution at that time did not have any concern with the substantial values of society as real liberty, real concern to liberty, only a formal concern on liberty and liberalism and the individualistic character of the liberalism at that time, but did not have any concern, deep concern on protecting human life at the level of the spirit, at the level of the anthropological character of man, and also and especially at the level of an axiological concern. But and although that time, for example, the Declaration of Rights of the Citizens, the Man and Citizen from the French Declaration of 1789, at its Article 16, stated already that if a constitution did not have or embraced it, the guaranteed rights of the man against the state or the separation of powers adequately, that would not be considered a constitution at all. But that time, although this idea under the Enlightenment movement came to the surface, once again, that was not sufficient. So the sum of the trend of contractualism and the sum of the trend of structuralism, there wasn't quite a concern on the man and the spiritual realm of the society and the moral evolution of society. But we now jump to the end of the first half of 20th century, and constitutional law and constitutionalism suffer something that I would call an anthropological axiological shift, especially after the Second World War, where the most constitutional democracies, or what I would say the greatest constitutions of the world, started at that time embracing values, core values, and substantial values on the constitutional text, as human dignity, as social values, as the idea of happiness and peace, and so many other kind of values that urged from the concern after the Second World War, and also were lifted at the level of the international level with so many covenants and declaration of rights. And for example, one of the most examples of this anthropological, axiological shift of constitutionalism is the German Constitution, the Fundamental Law of 1949, the Grundgesetz. At its Article 1, it says, originally, die Würde des Menschen ist unantastbar. Sie zu achten und zu schützen ist Verpflichtung aller staatlichen Gewalt. Translated, the human dignity is intangible. To protect it and to promote it is the duty of all state power. So here we have a constitutional concern or embracement of some substantial values to develop constitutionalism further and beyond the idea of contractualism and structuralism. But one would now ask why or when or how do we put or bring spirituality into these background of three trends that constitutionalism involved, like an Fibonacci explanation throughout space-time. How will bring spirituality, and why do we need it at all in constitutional law specifically? What I would say is that we have to look further on constitutional law, not only above man-made law and natural law, but also beyond natural law. Previous speakers said about natural law's importance, and Professor Sima also asked about it. And this is a quite interesting issue to say and develop and think about it, because when I say here about spirituality, I would go beyond even the idea of natural law. Because, for instance, one general rule or precept or principle of natural law theory that came from reason or the state of or the nature law is that one should not kill other. But why one should not kill other? There is a criminal offense above this statement, this natural law precept, but spirituality and the akashic values are beyond that. One should not kill other because we all must love others. And this is the idea, the spirituality with the A field, what I call the akashic values field, and natural law with reason, and we think about mind, we think about thought also, and here we are with constitutional law, man-made law. And how to integrate spirituality. To understand more about spirituality and this entanglement with constitutional law, for me, we have to go back a little bit to the beginning of the 20th century and bring also quantum physics and science and a general basis to the equation. Because we have some at that time, we had some developments, scientific developments that we can neglect, like Einstein's special relativity, where he proved the interchangeability of mass and energy, and the well-known equation E equal mass c squared. And Einstein's also general relativity, where he proved that gravity is not a force itself between attracting bodies of mass, of matter, but actually gravity is a byproduct of the curvature of space-time. And also we have at the level of quantum physics, the double slit experiment of Richard Feynman, where he stated the principle and the duality of wave particle. And then we have Werner Heisenberg bringing the idea of the uncertainty principle as a fundamental principle of quantum physics. And then we have also the great idea of string theory, bringing the idea, the core idea that reality is not real at all. Everything we have is vibrating strings in different patterns. And these different patterns generate the particles, generate the material world. So I think that one should also, at this point, ask what constitutional law has to do with quantum physics and to physics at all. If we think, for instance, at Einstein's equations on special and general relativity, we must think about it that constitutional law on its core is about mind, thought, and reason. These three are elements that form consciousness, and consciousness is a complex of waves. So we could say that analyzing at a microscopic level, that constitutional law is not only a man-made product. Constitutional law is a complex of energy waves flowing throughout space-time. So we do have to look at constitutional laws through the eyes of physics well. So where do I want to get with that? So when you see also general relativity and the idea of the curvature of space-time, we can see also, and also I wrote a paper 3 years ago talking about that, between the constitutional law and quantum physics, and defending the idea that constitutional norms have quanta. The idea of quanta, as Max Planck said, the quantum of light, that light is spread, the electromagnetism, the electromagnetic waves, and Einstein said later about light, the electromagnetic waves are spread in quanta, in little packages of energy with finite values. So I said 3 years ago that constitutional norms defend the self-normativity and execution of constitutional norms, that they have also quanta as energy waves in quantum states. What is that? Once Ferdinand Lassalle said on his great masterpiece on the essence of constitutions, he said constitutional law and constitution itself was a mere sheet of paper, because the real constitution was the sum of the state powers and the social powers and the relation between social subsystems like economics, politics, culture also. And to think about constitution as a sheet of paper is a sheet of paper without any kind of normativity. But like 40 years later, Konrad Hesse, a German constitutional law, he former judge of the Bundesverfassungsgericht, the Federal Constitutional Court of Germany, he said on an essay that he wrote about the normative Kraft der Verfassung, the normative force of the Constitution, he said that all the constitutional norms have itself an energy, a normativity, and that must be respected. What did he have to say with that? That constitutional norms are not political entities. Constitutional norms are norms itself. They are, and they embrace a force of ought to do, and that must be accomplished at the realm of society. So the idea of quanta of constitutional norms is to bring the idea that the quanta of constitutional norms curve space-time, curve the social political space-time. So where do I put spirituality in there? I have to bring string theory to think about it. Because string theory rose at a time that quantum mechanics at the microscopic level and the idea of the physics of the microscopic level, the special general relativity of Einstein, and they brought together onto one set of rules, but gravity wasn't quite enough being found at the microscopic level. Gravity was contradicting with the laws of the microscopic. So Einstein's equations of the macro was were contradicting with the microscopic level of quantum mechanics. And string theory brought through its theoretical foundations an idea that would eradicate these contradictions, this theoretical contradiction, and would bring gravity to its theoretical foundation. But actually, what the modern scientists with their experiments are trying to reach is the one explanation of everything, a theory of everything. And they quite found it yet, because there's still a missing element. And some modern scientific research are bringing that new element to the equation, and that new element is consciousness. So if we think about constitutional law as having also a quantum effect, a perspective of physics, we have also to see that there is an entanglement between spirituality, constitutional law, and quantum physics. So as constitutional law being a set of waves, of energy waves, why do not think about it, constitutional law also at the realm of consciousness? To finalize that, what I tell you about the Akashic values, as at this Akashic field, at the cosmos axiology, we have values, core values like love, compassion, we have empathy, we have solidarity, we have fairness, we have loyalty, and all these values must be embraced at the constitutional level. And they must be used as a parameter at the constitutional interpretation, at the constitutional adjudication. So spirituality is not religion. Spirituality is more than religion. Spirituality is beyond the theoretical and dogmatical boundaries of religion and the individualistic aspect of faith. And spirituality unites us into the oneness, into the Akashic, into the idea of values that are also above natural laws idea. So I'd like once again to thank you, Dr. Sima, for this opportunity. And this is a deep subject to develop. And I hope that I could contribute to this conference. Once again,
thank you so much, Mr. Rodrigo. Thank you so much for giving altogether a very new dimension to law and to correlating with the quantum physics. And would you suggest any text which, as per your understanding, better explains the relationship between the law, spirituality, and science?
Thank you for this great question. So first of all, the interconnection between constitutional law on a general basis, and quantum physics can be was already treated by Lawrence Tribe on his, I think the title of his paper, he has a full paper from the end of the 70s that is called The Constitutional Curvature of Space-Time, something like this. And he wrote this piece, this great paper, and he applies the idea of special and general relativity to constitutional law and bring it to with simple and political language, and he demonstrates the impact of these great and breakthrough ideas of to the formal and classical Newtonian way of thinking physics and science on a general basis, and he brought that constitutional law. But and especially when I wrote about quantum physics and constitutional law, the idea, the core idea was to reinforce that constitutional law, first of all, is not a complex or a set of political norms, because we had that idea years and years ago. Like, for an example, the Weimar Constitution for 1919, the German Weimar Constitution, had a compound of social fundamental rights, but those fundamental rights were practically nullified because the understanding underlying then was that the constitutional norms were only like general political principles. And then when Konrad Hesse brought the idea of normativity of constitutional law, this conjunction between quantum physics and constitutional law is basically to view constitutional law through the eyes of the microscopic level and see that every constitution, even at its preamble, that normally, for example, here in Brazil, we generally on a doctrinal basis say that our preamble has not an enforceable force. The preamble is not actually enforceable at court, but we have to interpret the rest of the constitution, the system of the constitution through the eyes of the preamble. But when we see through this kind of microscopic level, we can see that all the constitution has an inner energy, and that is quanta. That is like a finite package of value. So when I read the Constitution, when I read Article 1 of the Brazilian Constitution, Article 1, number 3, that states that the human dignity is the foundation value of our republic, I have to see that through the eyes of the quantum. See that in every aspect of our constitutional adjudication, human dignity is not a rhetorical formula. Human dignity is a value, and this value today that we are speaking through the lens of spirituality must be embraced by the next level, the level of the cosmology, axiology, and the level of love, compassion, and empathy, and tolerance, and other core values of society. So that's the general idea of quantum physics and constitutional law, but it's not a new idea or my idea. That idea has been developed through space-time. And I recommend all to read the Lawrence Tribe paper on that. That's awesome also.